At what point should I be thinking about intellectual property? Is it at the stage of concepting? Is that the word correct? Conceptualization of the idea? Is it much later when somebody has come to me and I'm feeling like it might be stolen? At what point should I start thinking about the intellectual property rights for the innovations I have? That's a first and specific question, but I'd like you to branch out and talk about what exactly should we be thinking about when we consider intellectual property in innovations. Should we think about, let me leave it open-ended because I'm sure there's a lot.
The first thing maybe to mention is that if you are in the area of technology or if you are likely to create something new, if you are likely to innovate, innovate to mean that you are building on something else that has been done before, or your invention is not new, from the moment you start conceptualizing the idea, I think that's really the time to start thinking of IP, your IP protection. Because you want to be able to put together the material that you need at the time of filing the application, let's say at the Kenya Industrial Property Institute, keeping in terms of protecting your work. But let me also, it's a bit disappointing, but a lot of people seem to think that what is protected, for instance, at a patent, is the idea itself. The law, IP law does not protect the idea in itself. So you may have lots of ideas in your head, you may even be able to throw them a bit and be able to explain the idea that you have in terms of solving a certain problem. But that's not what the law protects. The law protects the expression of the idea. So you must move from the idea to being able to industrially apply it. So you must show how are you actually solving a certain problem in life. And that is what will be protected in terms of it. And so you need, to have a good record of the things that you can bring with the idea as you move along in terms of finally reaching to a point where you can actually say it's an invention that you can protect. The other important thing to note is that for patents, it must be new. So if you, for instance, come up with something, but somehow you tell the whole world about it, it's no longer new. You have revealed it to the rest of the world. And once you do that, it is no longer new. So it's not protected. So you must have a way of keeping your information out yourself. And I may also mention that protecting your idea or the expression of the idea through IP is not the only way to protect your IP. You could choose to go the route of a trade secret. And for instance, the most famous trade secret that has been kept is the formula for Coca-Cola. They have never gone through the process of getting a patent for it. They just decided they will do it as a trade secret. Now, that's one of the rare instances when you are able to protect your idea. But of course, that means that you can never allow certain people, or rather you have to be so secretive about it so that nobody ever gets to know it. But of course, if they get to know it and you have not protected it, they can use it and they can be able to exploit it commercially. So the flip side of a patent is that once you reveal it to the world and you're given a certificate of protection, then you are given a period of 20 years of exclusivity, that you are the only one who can be able to sell, exploit, license that expression of the idea in that period. So you give to the world, but you also protect it. For a trade secret, you keep it to yourself, but you have the struggle or the problem of having to protect it. You also mentioned that when you talk of IP, a lot of people you hear a lot of people talking of, I have copyright, or I have a patent, or I have a trademark. It's also important to identify what area, what IP protection do you want of whatever you have. And some ideas can be protected in one or more ways. But people who use the terms loosely without identifying exactly what it is that they want to protect. So it's also important to understand what is it that qualifies as copyright, what is it that qualifies as a patent, what might qualify as an utility model, and so on. And basically, and I'm sure my colleague here will perhaps mention more, copyright is more of things that are like literary works. I think it's best to give examples, like our work of art, like a book. If you write a book, you have copyright in that book. Whether or not you register it, you already have the right to that book, but you want to go the extra step of protecting that copyright by registering a copy, for instance. Patent is what I've talked more about. It's going to be an invention, it must be new, it must be industrially applicable. Trademark is more of the sign that you use to trade. If you think of Cisco, for instance, that is a trademark. So when to start, going back to the initial question, when you have an idea, you need to start thinking of the IP right from the word go. You need to identify which IP right that you want to protect, and then please get some advice. The good thing is that there is a lot of information now on the net also. So by now, if you're already working in the area of innovation and so on, I would expect that you're going to keep his website and gotten to have an understanding, or at least some basic understanding of the various options that you have in terms of protecting your invention. That for now.
Thanks. Mr. Kendo Paul, you work at the Kenya Copyright Board, and I know at Swahili Board, we have sent some people your way to talk to you about protecting works and what that looks like. I'm just curious from a point of view as a state agency responsible for copyright works, what options are available to the people in this room in terms of protecting their ideas as they continue to develop them?
Thank you. Now, allow me to first of all define IP properly. Now, IP is intellectual property, is the intangible property that is the product of creativity. So when you create something out of your mind, that is intellectual property. Intellectual property is divided into two forms. We have industrial property, which my colleague was talking about, the patents, the trademarks, industrial designs and the like. Then we have copyright. Now, copyright protects the expression of the idea. My colleague has said that it is not the idea that is protected. It is the expression, when you express it. You may have an idea. You want to create a software for maybe to be used in the health industry to do a particular thing. That is an idea until it is expressed. And it is protected as soon as you put it down, maybe in a CD or you have stored it in some form. Now, copyright subsists as soon as it is created. So first of all, you must realize that it is not mandatory to register your copyright. It is not mandatory. However, it is advisable to register it because it makes it easier for you to commercialize it. It also makes it easier for you to manage your IP, the copyright aspect. Also makes it easier for you to prove ownership in case of a dispute in court. Now, most people actually approach the Kenya Copyright Board, and some people have been sent by Samuel and other people to come and register copyright. And the process is very, very simple. You can either register through the online registration portal, where you just raise a link, and then you just upload your work there. Or you can fill a form and then attach 2 original copies of your work. We have a stand just towards the entrance, and we have forms for registration of those works. So if you want to register your work, you can actually do it today or tomorrow or before Friday. We are still here. The cost 1,000 shillings. What options? Other options are there to protect. Like my colleague has said, you can keep it secret. Or you can just register it and then let people know about it, but then you are protected. Nobody can commercialize or use it without your consent or without your license.
I would like Clive and Agnes to speak about policies that would support innovation, especially in centers like universities and innovation hubs, where students are very proactively churning out new ideas. But before I come to the both of you, Dr. Wanjao, if I can just, within the technology world, we've got alternatives such as open source material, where you've got works that are freely available to use or reuse, everything from content to as complicated as software. And some people tend to argue that to support innovation, a lot more of these innovations should be made freely available and open to many other people. I'll give a couple of examples. Right now, it's very easy for many developers here in the room to connect their applications to, say, a payment system like Mula or M-Pesa, right? But many people do not remember that years ago, the M-Pesa platform was not available to innovators, so it made it difficult for innovators to accept or receive payments. Now, while I know M-Pesa is not open, there are many other tools that are open. So my question is, what is the balance between having protections for your idea, but still making it available to as many people as possible so that it supports other innovations going down the road? What's the balance there?
I think that's a million-dollar question that continues to be argued all over, and I think it comes even more alive when you think of innovations in the area of pharmaceuticals. And there's a big debate about it, particularly with the advent of HIV/AIDS, even at the World Health Organization level. And the question there was always, should pharmaceutical companies be charging the kind of money that they charge for the medicines? Actually, they just make this technology available to India, for instance, that have so many companies that are willing to channel generics of medicines for the benefit of the poor, the sick, and so on. And of course, there are justifications on one side that they spend so much money on innovation, inventing and development, that they need to recoup the money. And that actually is the basis for patents. That you spend money to develop technology, and therefore you are given, on the other hand, you're given 20 years of exclusivity to it. So I think it's a question of, I think it's a personal choice at the end of the day for the developer. You may want to be helpful to the world in terms of, like we say, you want people to build on your work. You want people to benefit from what you've done, and they perhaps do better things with technology that you even have imagined yourself, and this helps everyone. On the other hand, some technology, I think it's also a fact, requires a lot of research, requires a lot of repeats and failures and so on, and employing expensive scientists and so on, and therefore there might be some justification that is need to improve the resources that have been put in the research and so on. So the balance is hard, but I think for those people that have released their technology to be fully used, I think that has helped a lot of people. I think with the advent of the internet and the fact that some technologies are free on the internet, I think this is what has sparked a lot of innovativeness, particularly in Africa, for instance. So, but of course, on the other hand, in our companies, we spend so much on dancing to people.
Right. I will open up the floor to questions, but I'd like Agnes and Clive, if you can just speak to what policies should be in place to support innovation, whether it's at the national, regional, or even the levels like, our institutions or the innovation hubs in the country? What policies or what framework should we have in place to support the students and the innovators as they begin to create and develop their ideas? You can start to decline and then maybe have this.
Thank you. I've spent a bit of time studying about innovators. And so there is the issue of, when you look at old school university education, it has been based on research and then goes through the process of production where they create patents. If you look at the innovations that have come in, they have always been tied to disruptive technologies. Disruptive technologies are technologies that come up in the sense that no one wants it at the beginning, very few people want it, they don't need it. As time goes by, they want it, then everyone needs it. If you look at things like M-Pesa, if you look at things like the iPad, today you look at everything is about the phablet and everything else. If you look at how people moved, for example, the issue of Blockbuster and then comes to Netflix and the other guys. If you look at the way Kodak was looking at themselves as a developing, as a film company, not as an imaging aspect. So all these things rely on disruptive technologies. Now, disruptive technologies are normally not accepted at the beginning. If you look at the innovators like Steve Jobs, you look at Tesla, you look at Marie Curie, you look at someone called Elon Musk, all these people, they broke away from the norms, the issue of rules. We are normally confined by the rules. You have to think in a certain way. If you are not agreeing with the professor, you are wrong. So when you look at those people, Elon, for example, went to university and paid tuition and did not finish his degree. What did he do? He said he cannot pay for tuition and be confined in his way of thinking when he can consult all the professors. When you look at societies today, we have a mindset. I specialize in fraud, especially in insider fraud. We have a saying, the Americans have 30% of the population are totally honest. 30% are totally dishonest. 40% swing. If you look at our society in Kenya, we have a certain mindset. I would say maybe 10% or 20% are totally dishonest. 10% are totally honest. 70% swing. So whichever direction you turn, if the systems don't work, from the mindset they join where it is most profitable. Now, if you look at ideas, then you'll find if you start something today, everyone else copies what you are doing. And they start immediately. So people tell you now, how do you get into production? I'm going to share, then I don't own the idea. So we have a kind of selfish agenda sometimes. So most of the issues, if you are innovative and you don't share, then you don't grow. If you share, then you also lose out on the market. So we need policies that look at one. Can we educate the people to change their mindset? And this is why I challenge the youth. Can you use the disruptive technologies to change the way we think? Because what is happening, when I teach, for example, they want to cheat. When they are cheating, they will not have time to do what? To innovate. How do you innovate? If you look at all those particular cases we have talked about, they all spent time, they went away from the formal education. They never stopped the education. They learned on their own. They kept learning. They kept testing the theories. They kept changing. So if you look at their characters, they were not sociable. And when we look at the university, then we say you conform to we have a saying, there's someone who said that I teach what I know, I reproduce who I am. So in most cases, people observe who you are, they act like you. So if we have to change the mindset, then we start with changing the way we educate. Because now, how do we make, because even Thomas Edison said, his patents were never protected, he never profited from it, but he sacrificed. All those innovators did not benefit. This is why we form groups now. Like now what is coming here, there's a bit of sacrifice from Mahmoud, looking at everyone else and saying, can you pitch in? Then from there now we can look at those people who are not sociable, who can be innovators. They can now come up and we can protect them and help them make a living out of the way they are doing. So if we change the norm, if we remove ourselves from the bounds, from the rules that are always governing us in terms of structures, because if you look at the big companies, they don't innovate. The only big companies that invent is IBM mostly. The others normally, some were left out of the market. Like Nokia said, we didn't do anything wrong, but we did innovate. So what are we looking at? We are looking at changing the rules. Can we accept people who appear to be antisocial, can have ideas that we agree with? Can we change our mindset? Can we change the way we deliver in the university? Because sometimes, if I'm teaching, sometimes I teach students who know more than I do. And when I'm teaching and they are challenging me, what I do is I tell them, look, I'll find out. Then I have to come back and tell them. But most of us take that challenge. What do? We feel threatened, we punish the student. What do? We discourage the innovation. So what happens at the end of the day? How do we filter the people who are teaching, how they impact that knowledge? How do we filter that there are guys who are going to be greater than you? I always tell my students, claim your space. Because in this one, it's your space, you look at it, and then you start finding out where is the gap. We forget, we stop copying what everyone else is doing. The other thing we need to look at is, how are we fitting in with the technological change? For example, when you look at the academic programs, I'm sorry to say, I went and did electrical engineering. That was my first degree. When I came out, there was nothing for me to invent. There was nothing for me to design. I couldn't get a job. I came out at a time when the economy was doing very badly. So what did I do? My first job, I got as a trained teacher. After that, I joined the military. So what happens after that? You keep moving and you change. Here I am, I'm looking at the students. So the whole issue is, the challenges enable us to start looking at things differently. If you look at the students we have, they are exam centered. They want to pass the exams. So do they have time to invent? Do they have time to innovate? Do we encourage them to innovate? So the whole policy change comes from the government has a structure to look at. We as universities have to look at issues of how do we encourage that innovation and encourage the bright students to also innovate. The other thing we are looking at is, look at the technology we have today. The Chinese are building everything for us. Do we have any policy in place to transfer the technology? I went to one shop with a phone, and someone was not able, I don't want to say which manufacturer, they were not able to repair. I went to Tomboya. A technician there looked at it and said, I will repair it for you. He repaired it and it's still working. The charging system was not working. So what are we looking at? Do we encourage those guys who have not gone through the formal education to get an appropriate technology transfer? Thank you.
So thank you for that. Just to pick up 2 points, and maybe Paul, I can ask you to respond to them. It seems that, and some people have had complaints about this, that within the existing copyright regime or intellectual property, maybe to what there seems to be some bottlenecks or some challenges with regard to supporting innovation, the policies that will hinder or may not exactly make it easy to support the development of people's ideas. From the board's perspective, what are those challenges? What would be the response? What's the general thinking about how we can solve those challenges or change how we look at supporting innovations through policy? But before we come to that, perhaps Agnes, you can speak towards the policy question as well.
My colleague has talked quite a lot about it, but I'd like to take a different line. I'm looking at Swahili Port Hub, I'm looking at the 6 counties, and I'm looking at what's our future. What are we getting out of this? And what policies should we have? And what different thing should we do as the Pwani Innovation, Swahili Port Hub and everything to ensure that it goes beyond innovation? Ideally for me, we might have as many innovations as possible, we might have as many patents registered, but beyond that, what then? The previous panelists talked about having peer reviews. They talked about you getting the funding, then you don't know how to go about it, okay? So for me, I would talk about having policies that, yes, would be able to have innovations registered, patented and all that, but going beyond that. Before we even have the innovations registered and patented, if it's possible to have a policy whereby we have industry players come on board to ensure that they are able to peer review these innovations that are identified, so that we are fine-tuning them and getting something quality, okay? Such that once it's registered, it can go beyond that. And we also have policies in place to ensure that there is continuity. These people, these are youths we are looking at who are supposed to generate an income out of what we come up with. So ideally, it's helping them be able to manage whatever they come up with. They get partnerships, they get funding, and go beyond getting the funding and growing a business out of it. So personally, that's where my passion is. Going over and above, registering, innovating, and building what we get out of it.
I've got two final questions before I open it up to the community. Dr. Andra, perhaps just after Paul, and picking up from her line of thought, is the legal fraternity globally, are you moving quick enough to support disruptive technologies? I ask this question because copyright was invented in the age of the books, the book system. And now we're in the digital world and we've seen people come up with hacks, right? For example, things like Creative Commons licensing or any of the other open content licenses, to sort of support the development of these innovations, even while the rest of the world tries to catch up. So I'm curious to see, like, from the World Trade Organization, because Clive also mentioned disruptive technologies, and that seems to be a frustration point for a lot of innovators here, that they are ready with some innovations, some of them really disruptive, but it just seems that there isn't enough of a legal framework to back that. And perhaps you can speak to that, but Paul, to the other question about the existing policies we have in place, what are the bottlenecks? Is there anything that the board is doing about them? I know we have the Kenya Copyright Bill. Is it 2017 or 2018? 2017. It will not 2018. So, and I know that has been processed, and there's been a lot of engagement with innovation communities about reforming that bill in such a way that it supports what innovators want to do. But I'd like you to speak to, like, some of the challenges and some of the things the board is doing to make it easy for these people to develop their ideas.
Thank you. Now, challenges. Of course, there are challenges, but I'm going to speak in relation to copyright specifically, because unlike industrial property, such things as patents, trademarks are the same that they were so many years ago. But copyright changes so frequently, such that the law is not able to keep up with those changes. So, like, for example, right now we are using the the Copyright Act of 2001. In the year 2001, and when this act was being passed, it did not preempt that we are going to have the use and commercialization of copyright in a digital environment as it is now. So one of the main challenges is that we have technology that evolves so fast such that the law is not able to keep up. Piracy, as envisaged in the 2001 Act, cannot actually be enforced in the current situation, because people are commercializing copyright in the digital environment. So people are no longer selling CDs in the streets. So somebody will not mind when their CDs are being sold in the streets, because somehow that makes people know about them, and they'll go probably to YouTube, and that is where you get the money from. Or now they'll download, they'll get to Skiza and buy your tune. So the piracy, the way it was actually invested, the time the 2001 Act was being passed, is not the same as it is. So that is one challenge. Technology moving so fast that the law is actually being left behind. Political will. Now, the Kenya Copyright Board is a state corporation. It only has one office in Nairobi. There has been attempts to ask for it to be devolved, but because the politicians are not seeing value in copyright, now they have not actually been really into it. Funding, again, has always been an issue in the board. The other main challenge, other than the political will, is lack of awareness. Awareness in relation to the right holders and users as well. Now, people don't know the value of copyright. The small clips, music clip that you create and it goes viral, it has a lot of economic value. The small software which you create has a lot of economic value, but the creator may not know the value yet. So they're likely, maybe, when they are deciding whether to license it through Creative Commons or to use other licensing forms, they see as if it is something very small. M-Pesa is a very good example. The person who created it didn't see the value in it. Now it is something that is a multi-billion-dollar thing. People don't know the value of copyright. And if that is, if awareness is actually created, people will actually make a lot of money. Again, banks have noted that currently banks are actually giving loans to the creative industry. Musicians are being given loans. I know at least one bank that is actually giving money, loans to musicians. That is Stanbic Bank. There is another circle that was giving a piece, and I don't remember the name. They're also giving loans. Now, it means that the people in the economic sector, the banking sector, are seeing the value in copyright. So when the users, as well as the creators, get to know the value of copyright, I think people will go a long way. Now, what is the board doing to deal with those challenges? But before I go to that, the other challenge is management of copyright, again, has always been an issue. Most people don't know how to manage their IP, their intellectual property, whether be it copyright or anything else. And those who know, and probably they give other people the power, the license to manage their rights on their behalf, then issues of transparency, accountability, and good governance comes to play. And being Kenyans are known to being greedy. You have heard of the collective management organizations, the MCSKs, the PRISC, the CAMP, and you know what happens. These people collect money on behalf of these creatives, but then this money does not get to the to the people who are supposed to get the money. So there is that issue of lack of, or a lot of greed, or lack of good governance. Now, the Kenya Copyright Board has actually brought up a bill. It has passed through the National Assembly. It has also passed through the Senate. So we are expecting that to be signed by the President anytime. And that bill seeks to address the challenges brought about by the internet. So we are going to have the internet service providers liability, such that if you put your content online and then it is infringed upon, then you need to give them notice, the ISP, maybe Safaricom, maybe Zuku, maybe which other service provider. Now, if they don't take action and pull down that content, then they're likely to be liable. That was not there. So when you see your content, your only option was to go to look for the person who infringed, and you can't get them. It's very hard to get that particular person. So what you're left with is just sit back. But now there is liability on the internet service provider, and you can actually go for the internet service provider for that. So I think the main thing that the board is doing is now amending the law to address those challenges.
Awesome. One of the things that perhaps we would love to hear from the community here is what policies or what ideas you'd like to see in the future amendments of the Copyright Act that would support the innovations that you're doing. But perhaps we can come to you, Dr. Andrea.
Yeah, I think you mentioned the question of whether the law is supportive of innovations as stands fair. And I think that don't have to that almost invariably the law almost technology or change always goes ahead before us humans or those that are in charge of putting laws in respect to the issue. So, and I think of any sector, most of the time, the number of the people that same thing. I think what's important, government, and it's not to let part behind it. One of the things that support a lot of people who have TV or whatever is going on in terms of protecting their rights, particularly people in the field, like I see most people are related to software, is that you can only protect them as the programs cannot protect computer programs which are for most people most of those more unfortunately, our law and classification only the complex is working upon. And so, if you come to me, usually you come to me before I have outfitted this
Excellent. I'd like to take two questions from the audience before we close this panel. I see two hands here. So we'll start on the back, then we'll come in front. I'll take the third hand as well. I see your hand. So let's start here. Is there a roving microphone? Yes, please tell us your name, where you're from, and then ask the question.
Hi, my name is Arafat. I study at the Technical University of Mombasa. Great discussions, great minds, good up. It's kind of like a very interesting discussion because I've been so much into that field to the point that actually last year I was named by the Standard Media among the Kenya's top 10 student innovators. Unfortunately, I've never requested a button. I have a reason to do that. Reason being is that some ideas are kind of like, to me, I will only register a patent if I know that it's going to turn out to be a successful business, period. If it's not going to be turned into a successful business, I don't even bother to them about copyrights and patents, right? However good an idea is. And the issue regarding patenting and stuff are, let's take the case of China, right? Americans created artificial intelligence, right? But then the Chinese are reaping benefits from artificial intelligence, right? Reason being, them are good at execution, identifying problems and deploying that piece of technology, right? Are Dr. Wanjau, like, okay, some of the speakers as well, are you kind of like give two examples of ways on how people can be able to protect their ideas, which is either you seek a patent or you just keep it a secret, right? But then there's also another panel I attended, right? And this lady, she's a great business person, she said, the best way to protect an idea is to build a strong business around your idea. An example, let's take the case of Facebook. Before Facebook, there was Friendster, and there was also MySpace, right? But then, why did Facebook succeed? It's because of their strategy. They used to bring their idea to market. And the guys of Friendster, up to now, actually, are kind of extinct, right? So that is the best way to protect an idea to me, is to build a very strong business around top of it, other ideas that the companies also share.
Thank you so much for your comments. There was a question right up front here. Mr. Mohammed.
Okay, and let's keep the questions short. Let's go straight to the point because of time.
So I think Mohammed Garib, everyone, from Alternatives. Now, I think there was, I would like to add to what he's just said. So there is the part that you have a good idea, but you don't necessarily, it might not become anything. And the more you keep it to yourself, you are actually harming yourself more than actually protecting yourself in the future, because you don't know if it will become a business. But my actual question was, how do we prevent our society from becoming like the American society, where there are trolls holding IPs? And at some point, I think you saw the most famous case where Apple was sued because of the curve on the phone. And Samsung says they come up with the curve, it's not Apple. And I think they were paid in coins. How do we prevent such things? How do we start a good thing, but with good intentions, so that we don't become the society like the American one, where you will be sued for literally everything. So everything that you come up with, somebody already patented it and it belongs to someone else.
There's no other panel want to respond to that. Dr. John, go ahead.
I think, yeah, and if you given a good example of the US, they have gone out to the extreme in terms of, you have protections, patents have been issued, but they are sitting on the people's growers and they are not being commercialized. Now, I think that's actually affecting the economy of the US because they could actually, some of those ideas could actually perhaps be given to some other people and was actually be commercialized. And I think I like the approach that was taken by the High Court, the highest court in India, against allowing people who just protect some very minor innovation or change to a people. So, and pharmaceuticals are very good at that. They will invent a drug, and when the 20 years of the protection is ended, they will when you test another thing, when you just make a slight validation, you get another thing, and then you get go from getting a test to maybe some kind of commercial and having other things. And I think, and go to me, when I say the word allow, it's called opportunity, as in give the patient please. So that concept of opportunity. When you don't allow people to take advantage of very small changes to technology, and they don't want to invent again, because they are stuck on the shoulders of others. They should let them benefit. As indicate the development of others, when they make a minor change,
It sounds like there's a lot of need for people, especially debaters, to pay attention to the legal process and the law and to make their desires and their needs known so that it's factored into future law reviews. So I think that's a direct message from this panel that you as innovators who are sitting here need to be aware about the legal implications and the laws that govern your ideas, the development of your ideas, and participate in any legal processes that will result in changes that benefit you, that help you develop your idea. There was one last question. We'll take that and then we'll close.
Good afternoon. Hello guys.
Good afternoon.
Okay, my name is Francis from SICOM. I have one question, or rather two. One is, what law really applies to IP? Because there is a laws of Kenya, there is a law in the US, there is a law in Uganda, Tanzania. I mean, so if you patent in Kenya, and you know internet is an open space, how does that apply when someone else launches the same product in another country? Second question is, how many litigations are actually happening in this country on this IP issue? Because, I mean, sometimes when we are talking about innovation, we would like to quantify the problem and see whether it's something that can prevent young people from moving forward, or is it something that might be a concern in the future. So I think the question is, how many litigations are actually happening in this country in that area?
I think that's an excellent question that Paul perhaps you can answer. With respect to, if I patent my work here, and I want to give a good example. Recently, the European Union passed a bunch of rules called the GDPR that resulted in every website having a button that says that we use cookies or we collect this information, and we all got tons of emails saying that this is the data we collect, etc. Does that apply to us here? Is it something we should consider? What laws, rightfully, should apply to us, and how do we know about them? How do we keep track of them?
I'll answer that question very simply. Now, you asked what laws apply because we have laws of Kenya, laws of Tanzania, and the like. Intellectual property is territory, generally speaking. So if you are protecting and registering your patent, your trademark, or other industrial property in Kenya, it is protected in Kenya. Now, if, generally speaking, again, you need to protect another country, you may need now to go to that particular country and protect. That is in relation to industrial property. However, there are some systems where when you are registering in Kenya, you'll be asked to nominate the countries where you want your industrial property to be protected in. So you'll nominate those countries. So you'll tick the countries that you want your invention to be protected. However, what you need to know is that intellectual property is territory. It is protected within the country which you have registered. So if you want it to be protected in another country, it needs to be protected. However, when it comes to copyright, now copyright is protected. We have an international instrument we call the Berne Convention. Now, under the Berne Convention, the member states are mandated to protect copyright of other member states. So, for example, if you are a citizen of Tanzania and you are Kenyan, and your copyright is protected in Kenya, it is automatically protected in Tanzania. I think the only place, you will correct me, Latari, where you may need to register your copyright for you to be able to litigate on copyright is the US. For the US, for you to be able to go to court, you must have registered your, as opposed to other Kenya and other countries, you don't need to register. So for copyright, if you are Kenyan, you have created your content, then it is protected in all the Berne Convention member states, the TRIPS member states. So that is in relation to the laws. I'll answer that.
Yeah, sure.
Then ask the question, litigation that is taking place in terms of the IP. Hello? Yeah, with regards to IP litigation, in Kenya generally, as a general statement, there's not much litigation that is going on. But on the other hand, perhaps some of the litigation that is going on, it perhaps does not come to the public eye because it perhaps had at KIPI level. So at the registration level, there is opportunities that are given to you both in the law for you to challenge the registration of a trademark, for instance, the registration of a patent. If, for instance, you think whoever has applied for it does not justify, is not justifiable, or has not justified why he should get the patent. So it's possible to bring actions before the Industrial Property Tribunal or before the Registrar of Trademarks. And because these are not high profile, they're not journalists who ever go there, so there's quite a bit of litigation that is going there. And it's until the decision is made by the registrar or the Industrial Property Tribunal that the case might then go on appeal to the High Court, and then you might hear about it. But on the other hand, we've seen quite a bit of litigation, particularly in the area of money transfer, software or programs or systems, where somebody claims this bank has exploited my idea. I was the first to develop this kind of system, and I went to them and explained to them the issue, and later on I saw them using the product in the market. And I think, I'm not too sure whether anybody has succeeded in any of those cases. And I think one of the major problems in terms of proving that case is having a clear record that you are the one who actually came up with the idea. And that's why, if you come up with the idea, just what we were saying before, is at the very least, even if it's not a patent, rush to the copyright board and register copyright in that expression of the idea that you have. Because at least in court, you'll have evidence that you are the one who conceptualized and who came up with the expression of that idea. And therefore, you'll be, by the time you're starting to speak to another party, a third party with whom you want to commercialize the idea,
you already have a record that you are the ones who came up with the expression of the idea. And another important thing is actually not even in terms of protection, is just to get a non-disclosure agreement, confidentiality agreement from the word go. Do not go discussing your idea with anybody else, but particularly when you're about to, if you're thinking of commercializing the expression of the idea that you have without some document. And one of the basic documents is to agree on a non-disclosure agreement, which you can craft it as wide as possible to ensure your protection. You may need the services of a lawyer to craft a good non-disclosure agreement, but even if you don't have a lawyer, there's still a lot of agreements on the internet that you can be able to pick and be able to improve on, or at least to express something that you have gotten some obligation on the part of the third party that they shall not reveal the information you reveal to them, and you stipulate for that information that you're giving them, so that again there's a clear record that they should not breach your confidentiality. And in fact, one of the litigation that I'm aware of that has succeeded in this sort of area is where there was an NDA, a non-disclosure agreement, because somebody was able to show that they were able to make the claim not just on the intellectual property itself, but on confidentiality, that an obligation was imposed on the third party not to reveal certain information or not to use certain information, and they went ahead and used it or revealed it to another.
Thank you very much. I think to end up this panel, there are a couple of key takeaways for each of us here that I want to summarize as we close. For the innovators, there is a very clear call for you to, one, know what the law says, two, participate in the legal process and how these laws are being made, and to speak up for your needs and desires of what you want to see in the law, so that may be able to support your innovations. I also think perhaps, and I think Dr. Anjao made it very clear, he said, if you've got an expression of an idea, please run to the Kenya Copyright Board. They have a tent here, pay 1,000 shillings, get your registration, or you can do it online as well. There's an e-corporate registration. This, I think, begins to help you as you support the development of your idea. One of the requests I would like to have specifically to the Kenya Copyright Board on behalf of this community perhaps, is that whenever there is an opportunity for us to engage in the review or to submit submissions about the process, please come and talk to us. Please let us know that this is now available. We'd be happy to come and speak to you. The governor this morning insisted that we even create forums for public participation. That's something that we intend to do for Rod Broad to Hilly and perhaps this is another tool that we can also use to make submissions. But I think it's also useful for you to interact with the team here and understand the needs, especially with the different teams as they go on their day-to-day process. For the friends in academia, I think we also need to start thinking about what policies or what knowledge we need to start gathering and collecting in order to support the processes, in order to come up with policies that support the ideas of these young people, and use our universities, our incubation spaces as testing grounds. I believe pilots, a friend was telling me pilotitis, so running pilots is the way new policy is being made. There's evidence that you can attach to submissions. And to our friends at TGChan, thank you for coming very much. But we invite you to come again. Usually when we invite you, don't come with your invoices. And we're very grateful for, and we do ask that the legal fraternity, not to sideline yourselves as those guys. We consider the legal fraternity part of the innovation ecosystem. And even as we continue through this conference and through the partnerships and in the long-term vision of building a strategy for the future of 3 to 5 years, we consider you all as a key and essential part of our community. So we encourage you all to be close to us. Please reach out and form direct relationships with these innovators and provide the guidance that is required. And so Heliport and many other people in this ecosystem would be happy to facilitate that process. Once more, please let's give a round of applause to our panel. Thank you so much.